Welcome to those of you who've just joined us. We were playing a video about Her Justice's program, and so to go off a little bit of what you saw in the video, basically Her Justice is an organization that helps low-income women in New York City with the areas of family, matrimonial, and immigration law. And the way that we do the work that we do is through pro bono attorneys like you in this room. So most of our clients are helped by pro bono attorneys at firms. And we're going to be giving this training today to give you an introduction to the areas of law that you're going to be working on this summer. And then the way we work is that we have a really robust mentoring program, and so you will be paired up with a staff attorney from Her Justice to be your mentor throughout the case. And so you should be reaching out to your Her Justice mentor to discuss case strategy, ask any questions about the substantive law that you may have, review any drafts that you have before filing, things like that. In addition, obviously your firms have also set you up in teams, and so you're going to be working with senior associates or partners at the firms. Your firms are a great resource for litigation strategy and sort of general legal advice, also to tell you about your firm's specific procedures, how to file in court. Your managing clerk's office from your firm should be handling those kinds of things. So just to give you a sense, if you have a question on your case, the very first place you should go is your manual, which you have two manuals in front of you, one for custody and one for order protection. If you cannot find the answer to your question in the manual, if it's an area of substantive law and family law, then by all means pick up the phone and call your mentor. If you have questions sort of about procedure, your mentor can help you with being familiar with family court, which, as you'll learn this summer, is very different from sort of federal court or other kinds of practice that you might be used to at a firm. But also, please don't forget to use your firm supervisors as a resource. As summer associates, it's also a great opportunity for you to get to know more people at the firm, get people to see the great work that you can do. Obviously, pro bono cases are really exciting for you in the sense that you're going to get to do a lot of substantive work very early on in your legal careers. You'll be going to court, you'll be interacting directly with the clients, and you'll be making the case strategic decisions in consultation with your mentor. So with that said, just to sort of touch on what we're going to be accomplishing today, this is a 2.5-hour training. So we're obviously not going to be able to get you out of this room complete subject matter experts, but our objectives for today are just to get you to understand the fundamental laws and steps in family offense proceedings. That's for your client to get an order of protection. The fundamental laws of custody and visitation proceedings, to have an idea about the information that you need to gather from your client and the steps that you need to take in order to develop a theory for your case to bring it to the fact finder in family court, and to identify how you can become an effective advocate, again, in consultation with your mentor and your firm supervisors. One other note for today, we're videotaping this training, so please be patient with us. If you ask a question, please always feel free to raise your hand throughout the presentation to ask a question. But the presenter is going to repeat your question for purposes of picking it up on the video. And with that, I'm going to turn it over to Wendy.
Thank you, Anna. So, as Anna mentioned, we represent low-income women. However, we also work out at different family justice centers where we also give advice to men who come into the office to meet with us. So I'll be using women because that is our clients, the majority of the clients that we meet. And one of the things that I wanted to do is just give you a sense of the area of domestic violence. So we're going to be talking about the dynamics of intimate partner violence. Okay. For our clients, not all of them are victims or survivors of domestic violence. So for the purposes of this training, we do have orders of protection, and clearly those clients have presented as survivors of domestic violence. However, just so that you know, not all of our clients. And so some of you may have just straightforward custody cases that don't have domestic violence as a component identified. However, there is a high conflict there, so you want to keep in mind some of the things that we're talking about to flag it. Perhaps that person did not disclose domestic violence when came to us originally. So I'm going to go over some fast facts, and please feel free because I'm going to need your assistance here to engage. What percentage of domestic violence survivors are women? Anyone? Oh, really fast. Come on. Anyone? I'm going to start picking. Okay, sir. 85%. Good guess. Anyone else? All right. You guys are going to be standing on your feet in court. If a judge asks you a question, you're going to respond, right? So no silence. Anyone else? 90%. 90%. Okay. Actually, it's 95%. Okay. Next question. Intimate partner violence affects more than how many people each year in the United States? Just a guess. 500,000. 500,000? How many people think 500,000 is a fair number? Someone says yes? 500,000 across the United States. Okay. 10 million. 10 million people are survivors of domestic violence. That is equivalent to 20 people physically abused by intimate partners every single minute. We're here for 2.5 hours, so you can do the math. Right. On a typical day, domestic violence hotlines received approximately how many calls nationwide in 2015? So this was a study that was done over the period of one day at various justice centers throughout the country, and so that were tallied. Not only justice centers, but just the hotlines that received the calls. So how many calls do you think were received in a day? Are any of these facts startling to you yet? Yes? Okay. Just Dominique. 2,000. 2,000. Anybody go higher? I'm like a bidder here. 10,000. All right. It's actually 20,800. Okay. So this is just to give you an idea of the nature of violence and how widespread it is, and we don't really see it. Over how many percent of all women will experience physical violence in an intimate relationship? What percentage? Ladies in the back. 90%. All right. It's actually 50%. Okay. So, there are a group of women, half of them will experience physical violence. Doesn't mean that it's an ongoing pattern, but it does mean that at least half of them will. To get out of a domestic violence relationship, statistically speaking, it takes about 6 to 7 tries to get out of a domestic violence relationship. So the work that you're doing here is very, very important. Okay. There were how many filings for orders of protection in New York State? This is the entire state, New York City and New York State in 2015. About how many filings do you think? These are the filings that you have. Some of you have the orders of protection. How many of those do you think were filed in 2015? That's the latest statistics that we have. Sir? 10,000. Anybody want to guess a different number? Sure. 3,000? All right. 59,050. And of those, 23,554 were filed in New York City. So the clients that you take on that are bringing family offense cases are very fortunate to have you. And then the last statistics over what percentage of people in family court handle their matters without an attorney. 80%. Okay, anybody else? 90%. She's right. You saw the PowerPoint, okay. All right, yeah, well, she was listening to the video. Yeah, over 80% of people in family court do not have an attorney to represent them. So what you do with these clients is extremely important. Imagine navigating all of the things that we're going to talk to you about in the next 2 hours on their own, okay? So again, I think that some of those are really startling figures. And I hope it gives you an appreciation for the work that you're doing. Okay, so definition of intimate partner violence. You probably didn't see this on the video, but can anyone just give me a quick definition? Dominique?
Like any.
All right, somebody help her out, co-counsel? Yes? All right, he's very smart because he's got the PowerPoint in front of him. So yes, a range of coercive and abusive behavior used to gain power and control over an intimate partner. Okay. And the goal is to create a fixed power imbalance. So you'll see that in your cases. You'll see when you start interviewing your clients, you'll see the power imbalance, and you can start talking to your client about that. And there are many different faces of what domestic violence looks like. And this wheel, it's a power and control wheel that was created. There are different types of power and control wheels. There are some that are specific to lesbian, gay, transgender, immigration, clients that are affected. But what we have here is the different types and facets of abuse and control that you will see in your cases coming up. So we have use of intimidation tactics. If you don't drop that case, something's going to happen to you. Physical abuse. As you see on the perimeter of the wheel, physical violence, sexual violence. Using economic abuse. A huge tactic, you'll see it in your cases. If you don't, drop the child support case, I'm not going to see the children. So keep these in mind, using isolation, using male privilege, minimizing, denying, and blaming clients. Some clients will say, I had no idea whether I was thinking straight, because everything that I would say would be contradicted. So you're going to hear these stories from your clients. All right. And we have a video link that Anna and I did about a year ago, or that if you want to see how an interview is done or get some tips from that, please visit this video link. Okay. So your first meeting. Your first meeting, you want to go over your client's rights and responsibilities. Your firm has a retainer agreement. We don't provide that. You are the attorney of record on the case. So you'll be signing a retainer agreement with your client to the specific case that you're dealing with, whether it's a straight order of protection case or one coupled with a custody or visitation matter, or a straight custody visitation matter. If the client has another issue that comes up, you would have to do another retainer. Attorney-client privilege and confidentiality. Amongst the group, you have your associate that's working with you, the partners. Some of you may have an interpreter working with you as well. All of that is privileged and confidential information. Okay, so we're getting into emailing clients a lot now. So if you happen to email and she copies a friend, you want to make sure that that person is not copied, because what happens, it breaks that privilege. Okay. Similarly, if you're meeting with your client, make sure that she comes by herself, so that the privilege isn't broken. She may say, well, I have my friend who was a witness to the violence. That's someone that you can speak to at a later date and make your own assessment as to how helpful that person will be on the case. But you want to have your meeting in private with the client, so that you don't break that privilege. Okay. You may start thinking, as you review your cases, start thinking about releases and forms that you might have her fill out. And also safety planning, very important. As each step of the case, as you approach the court date, after you leave as you enter the courthouse, as you leave the courthouse, you want to think about safety planning. And each of your cases is going to be very different. So the facts that I might mention on one particular associate's case will be different from another summer associate. So although you can, exchange general information, we would urge you not to share information like giving clients names over, or I met so-and-so, because you never know what connections we have. This is a very small world. So you don't want to break that privilege even amongst your colleagues. So you wouldn't say, I met Mary Smith, and this is what happened to her on, March 3rd. You want to be very, very protective of your client's privilege and, respect that what's happening to her is a private situation. Safety planning in the courthouse, there's an office called Safe Horizon. So if your client feels uncomfortable sitting in the court area, the open court area, with the abusive partner there, you can have her wait in Safe Horizon. And throughout, again, you're going to be talking to her about safety planning. If you're settling, and Anna will talk about this later, if you're settling a stipulation on custody and visitation, in the back of your mind, is that a safe location for your client to meet? So think about it throughout your case. Preparing your client. You want to get her involved. So what you want to do is give her, if you need to give her some tasks, a journal perhaps, keep her informed throughout what steps you're doing. This is what court is going to look like. We'll talk about, visiting the court later, but you want to keep her informed every step of the way so she understands, especially if you're using an interpreter, that she understands what she needs to do and what she can expect of you. When you keep her informed and involved, you also can manage her expectations, okay? One of the things that the next bullet point you want to make sure is that the client does not discuss the details with her children, okay? Very important. If the court senses that the client is talking to the child about the case, that's not going to be very good for her, okay? Obviously children have ears, they listen to conversations, so she should be cognizant of, not talking about the case in front of the children and around them. And similarly, they should not be at the meeting. To the extent that she can get a sitter, and you're not going to have childcare available at the firm, I imagine, but you want to make sure that she doesn't bring those children to the meeting. It's a very sensitive topic. You're going to get into details that you don't want the children to be involved in. You always want to make sure that your client puts her best foot forward, that she interacts positively with all involved. There'll be a lot of players, and we'll talk about who those are, but you want to make sure that her position is always in the interest of the children, to keep herself safe, if that's your case. Because if she starts looking like she's trying to interfere with the relationship between the other parent and child, and incidentally, we also have some same-sex couples as well. You want to make sure that doesn't come across. So you want to guide her. And people are going to be very frustrated. They may have been going to court a lot. They may never have gone to court before. But you want to make sure that all of her interactions are positive. She may have to speak to the child's attorney. So you want to make sure that is always in the interest of the child. Also, in the courtroom, no outbursts. You want to make sure that she's in control. And we've seen these things happen, which is why we give these advisories. Again, explain the court process and manage her expectations. If she thinks that you're going to get her a 20-year order of protection, it's not going to happen because you've already explained to her the law that New York doesn't have beyond 5-year period. When you're talking to your client, you want to understand what is her relationship with her partner. What brought them to court? What is the type of abuse? When we look back at that wheel, was it intimidation? Was it harassment? What was the type of abuse? Was it verbal abuse, financial abuse? So that you can start thinking about what your case is and the theory of your case. What kind of contact are the parties going to have? Are they living in the same home? And we have those kinds of cases. Are they living very far from one another? Do they work at the same location? How much contact? Because when you're asking for certain relief for her, you want to make sure that she's protected and that relief is included, which we'll talk about. You want to know the history. Were there violations of orders of protection in the past? Is there a pattern where maybe the person was arrested? How have they violated the order? And that'll inform you to how litigious the person is going to be. And what are the underlying motivations? What are the reasons for seeking the order of protection or for seeking custody? And Anna will talk a little bit about the custody dynamics, but you want to know what is the reason. If there's been a long absence and all of a sudden the person wants to visit, what is the reason? If all of a sudden there was an altercation, what prompted that? What was the motivation? Okay. So what we're going to do now is talk about where you go. Which courthouse door does your client enter? And there are a number of avenues that the client can get some relief for an order of protection. When I say order of protection, I also mean it also goes by the name of family offense. So I'll switch back and forth. And you can get that in, here's the first door, Supreme Court. Okay. This is where a client is seeking a divorce. This is for married parties. They're seeking a divorce, and within that divorce, they're seeking pendente lite relief to get an order of protection. All of your cases are in the family courts, so this is not the door that you're going to be going through. But it could be that during the course of your case, your client is served with a divorce proceeding. Hopefully that won't happen. We've reviewed the cases. We've vetted the cases to see if that is going to come up. Mostly all of your cases will be in the family court. Criminal court. A client can get an order of protection in the criminal court when there's an offense, a crime against her. She calls the police come, he's arrested, that case goes to the criminal court. You will not be going through that door, because that is the case with the prosecutor. The district attorney's office is handling that case. However, you can have your client go through that door, talk to the district attorney, and then also file in the family court. So you can have two cases running simultaneously for the same the same offense that was committed. Is that clear? Then this is the door you're going to be going through, the family court door. You're going to be meeting with your clients. You should take a court tour if you can, if you have enough time. I know some of your cases are coming up soon. Sit in on the part of your judge or referee or whoever's hearing the case so that you become familiar with it, know where the location is. So in the family court, you'll also have other types of cases going on. If your client has a custody case, most likely you'll be working on that case as well with your colleagues. They may also have a child support case. I don't know if anyone has a family offense and child support case. Have you all gotten your files yet? Yes? Does anyone have a child support case coupled? This gentleman here does. And back there you have one. So you're going to be going to court on two different occasions. They're usually not held on the same day because you're going in before different parties. Okay? One will either be a judge or referee, and then for the child support case that you have, it'll go before a magistrate. We have a separate training for that. And then finally we have the IDV court, which is the Integrated Domestic Violence Court. It's under the umbrella of the Supreme Court. And it's a separate part. The idea was to, if a client, if the abuser was arrested and they also filed a family case, this special part, which has one judge, would hear both cases. So that judge is privy to what's happening in the criminal case as well as the family case. So they're hopefully more informed about what's going on with this family, as opposed to that other track that I mentioned, where there's one judge in criminal court who has no idea what's going on in the family court. So some of you might have cases that are under the umbrella of the Supreme Court, the division of the Integrated Domestic Violence part. Okay, so who are we going to meet in court? Your client. This is a special proceeding. Family offense cases are special proceedings. And rather than plaintiff and defendant is what we're used to seeing in civil cases, they're known as petitioner and respondent. So if I'm mentoring you and you happen to say the plaintiff, I'm like, well, is there a case in the Supreme Court? Or is there a case somewhere else? Is there a civil case? So just note the words when you're in court. As I mentioned, you can have a judge on a case, but not all cases, custody or family offense cases, are in front of a judge. They could be in front of a court attorney referee, who's an attorney just like all of us here, who's been empowered to hear these types of cases. Judicial hearing officers are often retired judges who come back and hear cases. So you might be in front of a JHO. The judge's court attorney is someone who's very important. Court attorney referees don't have their own court attorneys because they're already court attorneys. But a judge will have someone who could be helpful in conferencing cases. So if your case is in front of a judge, you might have to conference your case in front of the court attorney referee before actually going to the judge. Assigned or retained counsel. That's your adversary or opposing counsel or the person representing the other side. If the person is indigent, they can be assigned counsel through the court. They'll be asked if they are going to bring their own counsel, which would be retained counsel, or if they're going to avail themselves of the court by being assigned counsel. So even though before I said that 80% of the clients go in without counsel, those are on all kinds of cases. Attorney for a child, and we'll get into this a little bit more, but the attorney for a child is representing the child if one is involved in a family offense case or obviously in a custody case. And they're to be treated equally with the opposing party attorney. So communicate with them as you would with the other attorney. You wouldn't want the other side to communicate with the attorney without you being present. Similarly, you should communicate in a three-way conversation. You'll have interpreters. You can bring your own, and they can interpret outside of the courtroom, but they won't be allowed to interpret on the record. They're official interpreters. Court officers will be your friend. They'll call your case early, and court clerks will help you get your decisions and orders. ACS and probation department, they are an arm of the Administration of Children's Services and probation department that go out and do investigations, and we'll talk about the court-ordered investigations later. And then all the cases, sometimes you'll see a live court reporter, but oftentimes there'll be a counter, and there'll be a tape recording of the minutes. So if you need to get a transcript, you want to make sure that you kind of note the time of when the case started and when it ended so you can get your transcript. Okay. So any questions on that? I know I'm moving a little quickly, but we're going to get through this. Family offense proceedings. This is a sense of your timeline. And you're going to be somewhere in the second, third, and fourth box. Okay. So ex parte appearance, that's the first appearance. You would not be at that appearance. This is the appearance that started the case. Okay. Your client did a lot before she got to your office. She went down to the petition room. She met with the clerk, or she met with the Safe Horizon personnel. She told her story, asked to meet with a judge or met with a judge. The judge decided whether she was going to be given some temporary relief, and then she's told to come back. So most of your cases are going to be on for first appearance or subsequent appearances. Does anyone know what they have now? If they have first appearances yet? No? It should say on your summons sheet. So look at that to see whether you're on for first appearance. If you're not on for a first appearance, which it seems like some of you, the case has already progressed, you want to know what happened at that first appearance, because that'll inform you about what you need to do when you go into court. Okay. So this is what we have: subsequent appearances, conferences. These cases move a little slow. a little faster than the divorce cases, but nonetheless, there are a lot of lag time in between. So it'll give you time to prepare. So it may be that you'll only have 1 or 2 appearances during your summers, your time. But what you do during that period of time is going to be very helpful if unless the case settles, and which is great, to help the associates who are going to keep the case after you go back to school. We have settlement options, which we'll talk about later, potential outcomes, trial and fact-finding. Unless the case has moved quite a bit along, you probably won't end up doing a trial, but each stage of the case is considered fact-finding, where you're getting more information. So what you say on the record is important. And then there's the trial and dispositional phase, and then finally an appeal, if so necessary. Okay. So we're going to take a look at one of the handouts we have. It's the first one. It's the family offense petition. Okay. So as I mentioned, and it's not up on the screen, but you'll have it in your handouts if you're watching the video. All the cases are in family court. As you can see, at the top it says Family FCA, Section 812, 818, and 821. That's the Family Court Act. So you want to become familiar with the statutes that govern family offense proceedings. As I mentioned, you have petitioner and respondent. You can have a client that's a respondent. And what does that mean? It means that the family offense proceeding has been brought against her. All the cases have 2 numbers, a file number and a docket number. For family offense proceedings or orders of protection, they start with the letter O, so that's easy to remember. And the file number follows the parties. So in the case that this gentleman has, where there's a support case as well, that file number, when you look it up, and you can look it up in the Unified Court System website, you'll see all of the cases related to those 2 parties. If they're different parties, then there'll be a different file number. So this is the information that the client brought to the attention of the clerk, and the family offense petition that was drafted to start the case. Okay, and in this case, the clerk themselves checked some boxes to indicate what the different offenses were. Okay. So does anyone have one of these in their file? No. Okay, nobody has an order of protection case? I thought we had a few. Even if you don't have one, it's important to know this, because it could be that one surfaces while the case is ongoing, and that has happened. So, or it may be that the client says, you know, I'm thinking about bringing a family offense proceeding. I'm thinking about asking for an order of protection. Can you help me with that? And so this, even though some of you don't have these cases, there might be people that are not here that do have it, because I know that there were some that were given orders of protection. And so the relief that's available for someone who asks for an order of protection is the following. The stay away, which means usually in the case where the parties are already separated, the individual is asking for the person to stay away. If you look at the next handout, it's kind of long, because now they started translating them, and this one is in Spanish. But in this case, we have a temporary order of protection, and you can see 01 says stay away. That's the first provision. So after the client went and told her story, she went before a judge, and the judge issued this order. And this order continues to the next court date. The next one, so under the stay away, you'll have specifics. In this case, it says stay away from the home of the individual, the school, the place of employment. Those are your common terms. You'll see that in all stay away orders. And here it also says subject to court-ordered visitation, which means that this client has children. And I can't tell from here because we blocked out the names, but it's possible that the children are also on this order of protection. But there's a carve-out provision for the parent to see the child, and it's not considered a violation of the order of protection. You can have no contact at all whatsoever. You can have no third-party contact. You can have some provision that says no custodial interference, surrendering of firearms, and these are all relief that when you see your petition, you want to look to see if that needs to be added for your client. You can have a provision where it asks if your client left the residence to go back into the home to collect the belongings or to allow the other person to come in to retrieve their belongings. More detailed relief is exclusion from the home, which is a little harder to get. So if a couple is living together and there's violence in the home, the client can say, I want this person out of the home. And there'll be a quick exclusionary hearing to decide if that person should be out of the home. And as each court date appears, they'll get an extended order of protection and the case continues to see if that's going to be the ultimate relief. The second one, and just to go back to the usual terms and refrain from, sometimes you can have a limited, or it's called a limited order or usual terms order, where that person can be in the home or doesn't have to stay away because there's, they have a need to connect. Let's say they work in the same place, but they have to refrain from, and if we look back at 2, refrain from these family offenses: assault, harassment, aggravated harassment, menacing, reckless endangerment, stalking, etc. We'll go into those next. You can also ask for your client's address to be kept confidential in family offense cases as well as in custody cases. You can ask for, if there was harm to your client, they had to seek medical treatment for that, to participate in a batterers program or get drug and alcohol treatment. This is something that's not asked for often, so the court can give you a little pushback, but if it's necessary in your case, you would want to ask for it. You can ask for a temporary order of custody, although they usually ask you the client to go file for formal order of custody, which is the area that Anna's going to be talking about, and as well as child support. You can ask for temporary order of child support if necessary in this case that the client brought. So when you look at your petitions, you'll want to know, where does your case fall into? Do you have an initial family offense petition, in which case the client never brought a petition before? This is the first time she's going to court, the first time she's asking for relief on this particular incident or altercation that happened. There are instances where a client has an order of protection, and for whatever reason they want to extend it. It hasn't expired yet, or in instances where it has expired, the client is seeking a renewal, and the client would have to go before the court and explain why she needs the extension or renewal. We talked about the exclusion already and violations. So you might have a case where the client brought her initial petition. During the course of the case, there was a violation. Either she reported it to the police or she didn't. If she reports it to the police, it's a mandatory arrest. If she does not report it and she just goes to the family court, then it's considered a violation petition. So some of you may have that as well. I mentioned IDV, the multiple cases. The IDV can also divorce a married couple and give other relief such as child support. If your client is the respondent, that means that this petition was brought against her. And in that case, you want to make sure that you defend against it, because there is that mandatory arrest. So if your client is the respondent, there's a possibility that if someone makes a false report or a true report, that person will get arrested. So it's very important to try and advocate for your client not to have an order of protection against her. And as I mentioned, there could be other ongoing cases as well. Okay. I wish I had a little like spinning wheel to pick one of these, but we're not that sophisticated yet. But these are the family offenses. Again, if we go back to the temporary order of protection, and if we go even back to the family offense petition, this person told their story. And I'm just going to read just an excerpt of it. And then you can tell me which of the family offenses was committed. So here she says, petitioner states that every day respondent gets to the house drunk at 2 a.m. or 5 a.m. and he comes home with beers and starts playing really loud music and does not let anyone sleep, even the children. Petitioner states that when he comes home drunk, he starts physically hurting her. She states that they have been separated and that she sleeps with the children, that sometimes the respondent comes to the bedroom where she's sleeping, and because the door is locked, he forces his way using a knife to open the door. She's fearful for her safety and the safety of the children as well, and is fearful for her life. What are the family offenses that you think, and there's 2 slides here, so there's that one, and you can look at your order of protection that already gave the relief. What are the family offenses that you think might have been committed? Yeah, you might want to take a look at the family offense, which is the next one. Definition of family offense. You want to know this. This is the penal law. This is what would trigger an arrest if she went to the police. So based on what I just described, does anyone tell me what offense he might be charged with in the civil action, the special proceeding? Assault, and what, and that would be based on?
Haven't made it to the definition yet, but forcing his way in using a knife to open the door with someone in fear for safety.
Right. That would be maybe intimidation or harassment, disorderly conduct. There's any number of offenses that could be listed here. So what you want to do is look at the actual the statute, the penal law, and then see, how do the facts jive with what the penal law says? And the good thing about the family offense is when you want to ask for an order of protection is you only have to prove one. So you wouldn't have to prove every single offense, but you would have to go through the elements of the offense. So if we just read, for instance, the first one, disorderly conduct, intentionally creating disturbance, inconvenience, or alarm by fighting, tumultuous, violent, or threatening behavior. Seems like that would be one of the offenses in the brief blurb that I described. So you want to become familiar with this statute and see where your client fits in, or where the facts of the case. And keep in mind that your client came at a distraught time. She went to the clerk. She may not have told the whole story. And this is where we get to reviewing and drafting the petition. So if she doesn't make out a family offense, and there's counsel on the other side, they might move to dismiss it. If she hasn't told her complete story, then what you want to do is review and possibly draft and amend that petition. Okay? So the standard that applies is lower than in criminal court. We all know that in criminal court is beyond a reasonable doubt. In family offense cases, it's the burden of proof, it's preponderance of the evidence, which essentially means it's more likely than not that this event occurred. It's more likely than not that he intruded into her bedroom, the locked bedroom, with a knife. And she would give testimony on that. So you want to make sure that you meet the appropriate statutory elements of at least one alleged offense. Aggravating circumstances, in this case, she said he sexually assaulted her. If you can prove that at a trial, then she can seek a greater length on the order of protection, which is up to a period of 5 years. So if you can prove aggravating circumstances, there was a weapon used, there was injury, there was a violation of a prior order of protection, you can allege aggravating circumstances and get an increased order of protection in terms of length of time. Typically, it's 1 or 2 years. For aggravating circumstances, these are the elements that you would need to prove. There was physical injury, dangerous instrument, prior convictions of crimes, exposed any household member to physical injury. So the normal time is up to 2 years without aggravating circumstances, and up to 5 years, and any in between that range, up to 5 years if you can prove aggravating circumstances.
And aggravating circumstances has to be a fact finding. You can't settle on that.
Right. You'd have to go to a trial on that. Whereas in the other cases, you would be able to just get a consent or an agreement to have the other person have the order of protection for a period of 1 or 2 years. Okay. Do we have any other questions on family offense proceedings?
Yeah, aggravating circumstances. Do you just need to show one?
You need to show at least one, yes. Yes. Oftentimes in these cases, there are more than one, but yes, you need to show at least one. And usually in these cases, particularly in the facts of this case, you can show, I mean, the court might even stop you and say, okay, I've heard enough, and then you can get your order of protection. Not all cases go to a trial or hearing. Many of them settle. Okay, so you can get a consent. Any other questions on, I know we went pretty quickly, but when we do our mentoring and you start talking to your clients and thinking about your cases, more questions will come up, and we'll talk about strategy as well. Okay.
Okay. We're actually, we're way ahead of time, which
okay,
is great.
So I spoke fast. I need more questions.
So just want to ask the room, do you guys want to take your break now before I start the custody visitation piece, or do you want to go through and take the break after? Anyone? I'm inclined to just go forward, so you know, it'll leave us more time at the end for questions. Great. Thank you. Okay. So I'm going to switch gears a little bit and talk about custody and visitation proceedings in family court. And although this might feel like a whole different training because it's a different substantive area of law, the reason that we do this training together with the order of protection is because, as Wendy already mentioned, many times your clients are going to have these at the same time. And any time that there is a custody case and an order of protection case going on at the same time between the same parties, they're going to be heard in the same courtroom in the same proceeding by the same judge or referee. So that's why to us, this is a logical combination. And as Wendy also mentioned before, even if your client thinks right now she only has a custody or visitation case and she doesn't have an order of protection case pending, you never know what might come up during the course of your representation. There might be things going on that haven't been reported, that she might not realize or identify herself as a victim of domestic violence, but the more she works with you and goes through the system, she might come to realize certain things that make her think she needs an order of protection. Or also, as Wendy mentioned, families who need the family court to resolve their custody visitation proceedings, these are not people who are getting along, right? This is a high conflict situation, and so that might bring to the surface or trigger certain behaviors or violent actions that may not have happened in the past, and all of a sudden the stress of the case or just the conflict that's present there might bring things up. And so that's why we feel it's important for you guys to hear both trainings on the same morning and not just come to one or the other depending on what your case is. So that being said, as I said, I'm going to talk about custody and visitation. I want to start out by asking you guys, who do you think can bring a custody or visitation case in New York State? Anyone? Let's start with the easy ones. Yes. A mother? A father? Anyone else? Grandparents potentially can. Any other ideas? Other family members? What defines a mother or father? We know biologically who can be the mother and father of a child. Can you think of any other circumstances where someone might be considered a parent who did not contribute DNA to the child? Any ideas at all? Yes?
Adoptive parents.
Adoptive parents, yep, great. Anyone else? Yes?
Anyone who's provided long-term care to the child.
Long-term care, so for example, a step-parent, a guardian who might have lived with the child and acted as a parent a long time. What about same-sex couples? Only one of those parents is going to be the biological parent. The reason I bring that up specifically is that in New York State, we just had a case decided last year that was a pretty important landmark decision. So just to sort of lay the framework for you guys, what it used to be in New York State was that the definition of parent was very strictly applied only to biological parents, so basically only to people who contributed the DNA to that child, which in this day and age of many different alternative families really wasn't working for the best interest of the child. It wasn't working for the best interest of the family, and it was bringing up these odd situations where, you know, you might favor a sperm donor person who'd never met the child before as a parent over someone who did not actually biologically father or parent the child, but has been involved in that child's life from day one, and that didn't make any sense to anybody. And so thankfully, the Court of Appeals last year decided a series of cases where there were a series of cases brought by, as it happened, lesbian mothers. Obviously, the laws are gender neutral, so this would apply equally to any gender parent. But essentially expanding the definition of parent to mean people who have contributed meaningfully to a child's life, who intended to be parents. So if there was an agreement between same-sex couple that one of the mothers was going to actually carry and bear the child, but the couple agreed that they were going to co-parent, those kinds of considerations can now be taken into account to give someone standing. In other words, to give someone the right to seek parental access or custody or visitation of someone who might not be biologically theirs. So that obviously that case was very important to the LGBT community, but it also has implications for step parents who, before this case was decided, no matter how involved they might be, their parental rights were always going to be lesser than the biological parents. With regard to grandparents, it's a special consideration depending on how involved the grandparent is with the child's life. They may or may not get standing. This is not an advanced custody training, so I don't want to get too deeply into the weeds on that, but I just want to introduce the topic to you guys to start thinking about who even has the right to come to family court in the first place to bring these cases.
The Sealy code is X72TC9. X72TC9. X72TC9.
For purposes of this training in your cases this summer, I don't believe we've placed any same-sex couples this summer, and so all of these cases that you are going to be working on are going to be opposite sex mom and dad, biological mom and dad, where you're representing the mom. So the custody and visitation timeline looks pretty similar to the order of protection timeline that Wendy already went through with you. So again, all of your clients have already gone to court at least once to file their initial petition. They went to the clerk. They either filed the order of protection and custody together, or they might have just filed the custody. And then once a petition is issued, the father has to be served in person with the petition. And then the first court date is called return of process, or the first appearance. And so a lot of your cases are being placed with you before that first appearance. Some of them are being placed a little bit later on in the timeline. So after both parties have appeared in court and it's been established that there's service, then the court goes on to have many conferences. An attorney for the child may be appointed. Settlement is really strongly favored and pushed in these cases because of the fact that, I mean, honestly, for everyone, custody and visitation trials are nasty. And so if it can be avoided, the court is going to do whatever it can to avoid having this end in a trial. But if the case cannot be settled, then it will go to a hearing. They're heard by the same judge or referee that's going to be hearing an order of protection case. And then there's going to be a decision and the potential for an appeal. So custody really encompasses two different considerations, which I think are nicely summarized in this chart. So it's not just about where the children live, although that is a very important part of custody, and where the children live is called physical custody. Who's going to be with them most of the time? The other part of custody is something that people don't often think about, but the legal custody is who's going to be making the decisions regarding the child. Who's going to decide what religion they're raised in? Who's going to decide what school they go to? And if, God forbid, there's a medical issue, who's going to be making medical decisions for the child? So we call those sort of major decisions. That's different from day-to-day decisions about whether or not the child can have a second cookie after dinner. But, you know, the major decisions, someone has to be making those decisions, and that's legal custody. You're going to hear a lot in court about sole and joint. Everyone loves joint custody. It's this sort of trigger thing where, and again, I'm speaking in gendered terms because our clients are all female, and most of them are in heterosexual relationships. But, you know, oftentimes it's going to trigger a dad when he gets served with custody papers and she says, I'm looking for sole custody. And he's going to insist that he wants joint custody. Nothing else is going to do. I love my child. I want to be with my child. And that's great. But what you, as the lawyer, really want to be breaking down is, what does that mean? So joint custody in the physical custody sense is actually really hard to accomplish, because joint custody really means like 50-50 time. And almost always that's not going to be practically feasible, especially when the children get old enough to go to school. No kid really wants to be living in two houses when they go to school, and it's going to make a difference which school they can enroll in, etc. I mean, really the only 50-50 joint physical custody things that I see working are when the parents live close together and the kids basically spend 1 week with mom and then the next week with dad. Most of the time, one of the parents is going to be the primary parent that they're going to live with, and the other parent is going to have visitation, or what we like to now call parenting time. And they're going to have a schedule of what days they're going to see their children. So where joint custody really comes more into play is under the legal custody. So most of the time when a dad says he wants joint custody, he's not thinking necessarily 50-50 time. Maybe he is, but he wants to be involved in that child's life. And to him, what that means is, I want to be able to call the doctor and find out what's happening. I want school records. I want to attend concerts or football games or whatever it is. That's fine. That can be arranged. That can be worked out. It doesn't necessarily mean that joint custody is appropriate. So what joint legal custody means is that both parents have equal say in the decision making. Can anyone think of why that might be a problem if you're talking about a domestic violence relationship? Just call it out. Why might your client not want to have to reach an agreement with her child's father every time she needs to make a medical decision? Yes. It's going to be problematic in terms of the dynamic. Remember, as Wendy said, in the domestic violence relationship, we're talking about a systematic pattern of power and control being exerted over your client over the course of their relationship. So she doesn't have power in this relationship. She's not going to be able to negotiate with him, reach an agreement. I mean, you know, some families can, and that's great. And it's honestly, it's better for the children if the parents can work together and be amicable and co-parent. If you have that situation, Godspeed, then, you know, do joint custody. But think really carefully about that before you agree to that. And the other thing that you want to think about is, even if you call it joint custody, in other words, the parents are conferring about the decisions, you probably want to put in the final order or settlement that one of the parents is going to be the tiebreaker. So a typical joint custody arrangement would be the parties have joint custody, but the mother to have final decision-making power. Guess what? That's sole custody. But don't tell the father, because he's got the word joint in there, and it makes him feel like he's involved. And again, this is good. We want fathers who are healthy fathers to be involved with their children and to feel like they have access. That's, you know, but again, you want to have that tiebreaker in there so that you're not sending these parties back to the courthouse every couple of years when they can't agree on something. Okay. Any questions on sole, joint, legal, physical custody? All right. So there's a few different types of custody cases that you might be involved in this summer. The initial request is obviously if the parties have never been in court before, they're just splitting up. They're just splitting up now and they want the custody to be decided right away, or sometimes the parties have split up for a while and they've been trying to work out a schedule and an arrangement on their own, and something's happened to break down that relationship, and that now they need court intervention. So the initial request, if the parties have been to court before, maybe they got a divorce and the divorce addressed their custody, or maybe they went to family court and had something in place, it's not working out, it's not going well, then they might be coming in asking for a modification. In order to get a modification of a custody visitation order, the person seeking the modification has to show a significant change of circumstances. This has to be really compelling. It can't just be like that, you know, I started taking night classes and now I want to shift my days and I need the court to come in there. Really, those kinds of scheduling things ought to be worked out between the parents, and the court's not going to have a lot of patience for that. And the reason the bar is set really high for modification is that the prevailing wisdom is that it hurts the children to have too much disruption. So if they're used to living with one parent, the court's not going to flip-flop that and move the child, uproot them, send them to another home, and have them get used to a whole new routine unless it's really compelling. There has to be a good reason for it. So again, I mentioned before, if there's little tweaks and changes that the parties want to make, they can always agree to something else outside of trial. So their custody and visitation agreement might say one thing. They can always do another thing as long as it's being worked out. No one's coming to check up on them. You know, the reason that you would go to court is when there's a problem, either that he's unilaterally decided that he's changing the visitation and your client doesn't agree, or, you know, something else is going wrong. A violation petition is when there's an order in place and one party is not abiding by it, so maybe they're returning the child late. Once in a while we get emergency cases where the fathers refuse to return the child at all. We've done emergency cases where the father has taken the child completely out of the city, enrolled the child in a whole new school, and then just called up mom and was like, you don't have custody anymore. So these kinds of things need to be heard quickly, obviously. A couple of things can be asked for in a violation case. You can ask for the visits to be suspended for a time, or if they're going badly in the sense that your client is afraid her child might be being hurt during the visits, then the visits can also be supervised to see what's going on. A relocation case is a case where your client wants to leave either the city or the state with the children. These are really difficult cases to win unless the other parent is going to agree, or unless he's so completely absent that it's not going to affect his parenting time at all. Because think about it, why is it going to be difficult to take the children out of the state if the father's staying here? Anyone? No one? Yes.
Because New York State strongly protects a father's visitation right, so to take a kid out of the state would make it visitation nearly impossible.
Right. To take the child out of state is going to make visitation nearly impossible. And the first thing you said is also correct, that New York State protects the father's rights. Sometimes your clients feel like New York State is going to protect the father's rights way more than they think is fair. But it is true that the right of both parents to have a meaningful and significant relationship with their child is so paramount to our thinking about custody and visitation that's why it's going to be really hard for your client to take her children to a place that's far away where dad's not going to see the kids as much. It's far easier to have a meaningful relationship with your kids if you can see them every other weekend than if you only see them in August because they live across the country. So in order to be successful in a relocation case, your client is going to have to show that the benefits to the child of relocation, not just to her, but really it's going to benefit the child so much that it greatly outweighs the detriment to the child's relationship with the other parent. And so Some examples might be if the child is very sick or has special medical needs that need to be addressed by a medical specialist that only lives in a certain state. Once in a while you hear about children with asthma or other sort of respiratory problems where living in a certain climate can help them. Having the presence of a support network or other family members. So if your client's originally from Virginia and she has nobody in New York to help her out, but her whole extended family is in Virginia, so the child's going to be able to be with cousins and aunts and uncles and grandparents. Obviously, if there's domestic violence, if there's a safety issue, it's going to be much easier for your child, for your client to leave the state if it's dangerous for her to stay in New York. What's not usually sufficient is the client got a new job and she needs to move for the job, because that benefits who? Her, mostly. I mean, having a nicer job benefits the children indirectly, but also what's not usually sufficient is if she has a new partner and wants to remarry and move to another state to be with him. Again, all of these things have to be weighed against the detriment to the father to have the children taken away. And that sort of segues me into talking about the main crux of any custody visitation case, which is the best interest standard. So I've already started alluding to it, but basically what any fact finder in a custody or visitation case is going to be thinking about is what arrangement is in the best interest of the child. Not in your client's best interest, not what's most convenient to the dad, but what is going to benefit the child the most. This is a really squishy standard, right? Like there's no bright line rules here. Everything is case by case basis. And so your job as advocates is going to be to present the best possible picture showing that what your client is asking for is actually going to benefit the child in these various ways. And there's a number of factors that are taken into account. The factors that you present are going to vary depending on whether your theory of the case is either that you're trying to show that the dad is an unfit parent, we call those unfitness cases, or both parents are pretty okay. Maybe they're probably both flawed people, we all are, but they both care about their children, but you're trying to show that what your client wants is really better than what the dad is offering, and that's called comparative fitness. And those cases are a little harder to really go to trial on and win, but those ones might be more ripe for settlement, because if the dad is generally reasonable, then hopefully you can reach an agreement that is going to benefit the child. So an unfitness case, you might be trying to show that there's been domestic violence, either against the children, obviously, but even domestic violence against your client. If it happened in the presence of the children, that is considered to be so harmful for the children to see that is an important factor. So important that it's actually in the statute that a judge or referee must consider domestic violence when making any custody determination. And by the way, that's also why orders of protection are heard by the same judge or referee, because you want to have the order of protection heard first. You prove that he committed all these family offenses while the children were in the room, and then you turn to the custody. You've already got the domestic violence prong taken care of. If the father abuses drugs or alcohol around the children, or even not around the children, but he's unstable, if he's driven drunk with them, if he's left his drugs around where they can access them, etc., then obviously that's not safe for the children. And then we sort of get into, again, this sort of what I call more squishy, touchy-feely things. So domestic violence and drugs and alcohol, I hope is sort of clear to everyone, including the judges, why that might be a reason to give your client custody. But then we get into things like willingness of parent to foster relationship. Again, I've been talking about how the courts and the law in New York favors having both parents have a meaningful relationship with their children, and that this meaningful relationship is in the best interest of the children unless really proven otherwise. So the courts take the willingness to foster a relationship with the other parent very, very seriously. Some referees honestly take that even more seriously than domestic violence, even though they shouldn't by statute, but some of them really do. And so this is a place where you have to be really careful with your client, because your client is likely coming out of, again, a high conflict relationship where there may have been domestic violence, but certainly, again, the reason they're in family court is because they are not getting along. They have serious disagreements about raising the children. That's going to be an area around where your client feels hurt, maybe resentful, especially if he's been acting out, if she's angry about the relationship ending, and the danger is that some of those feelings of hurt and resentment might be spilling over into the children. You have to carefully instruct your client that she has to be so careful not ever to talk about dad with the kids. Don't question the kids when they come back from visits. You know, who was he with? Where did you go? These are things that are really potentially could make your client look bad. And so the best way for her to present is to come in and say, I don't want to interfere. I want him to be a good dad. I want my kids to see him, but I just want it to be in this structured, safe way. And that's the best way for her to present. Status quo is what I mentioned before, that the courts don't like kids to be bouncing around their whole lives. So if the parties have been separated for some time and the child has been living with your client for 4 years and now dad's coming in and asking to change custody, even though there's no formal order of custody, the court is going to take that status quo very seriously. There's going to have to be a really big showing to move the kids out of the home that they've known their whole lives. The same thing goes for being the primary caretaker. If your client has always been the one to take the kids to the doctor, help them with their homework, prepare their meals, drive them around, you know, then this is going to, again, weigh heavily that she's going to be the better parent to continue doing that care primarily after the case. Some other factors that you want to think about: compliance with prior orders. So if he has a history of violating previous visitation orders, then that tends to show that he's not being a responsible parent and he has a disregard for the court process. The wishes of the child. Our clients think that this is a big deal. It's less of a big deal than a lot of people think, depending on how old the child is. So a teenager who expresses that they want to live with mom or dad, that's going to be weighed really heavily. A 5-year-old who says, I want to live with dad because dad lets me watch TV before bed and mom makes me do my homework, you know, again, not as compelling. So you have to really think about the circumstances of your case. With regard to siblings, courts try to keep siblings together unless there's a compelling reason that they should be separated. What is not usually considered, but your client might want you to bring up, and so you have to sort of manage her expectations around that. There's no presumption that the mother should get custody, so both gendered parents are considered equal under New York law. There's no consideration of other sexual partners, so a lot of times you hear, well, I don't like his new girlfriend, I don't want my kids around her. When families break up, eventually the parties are going to probably find other people to date, so that's just going to be something that the kids are going to have to adjust to. Again, unless that new partner is in fact abusive, alcoholic, you know, problematic in other ways, but just the fact that he has sexual partners or a lot of sexual partners is not going to be the thing that wins the case for you. Sexual orientation is one that we see coming up once in a while in stricter religious communities. Just because your client or the other parent has come out as LGBT does not necessarily mean that they should be restricted from the children, even taking into account the religious beliefs of the community. Financial status is one that worries our clients a lot because obviously all our pro bono clients are low income, and they hear a lot, especially on the economic abuse side from the fathers, oh, well, I'm going to get the kids because I can give them a stable home and you live in a shelter, or, you know, you've only got one room. Again, this is balanced against other factors, so if the place where your client is living is really unfit for small children, that's one thing, but just the fact that she has less income than the father doesn't mean that she has a disadvantage. That's the whole reason that we have child support. Because whoever gets custody is going to have child support paid for the other parent, and that's intended to balance out the household incomes a little bit. So, you know, I've tried to cover briefly the best interest factors. Again, I can't emphasize enough that this is so case by case, and so you should be carefully interviewing your client about, get a whole picture of their lives, the life of the children, really try to understand, like, what is the kid's routine, who's doing what in the family, not only what are the problems, but also what are the good things between the parents, and talk to her about what kinds of an arrangement and schedule would work for her and the kids. Okay. I've addressed visitation parenting time sort of throughout the presentation so far, but basically visitation or parenting time is the flip side of custody. And a court is almost always going to consider visitation even if the father never formally files a petition. So the way it's supposed to happen is your client files for custody, he cross-files for visitation, and that's his formal request. If he never formally requests visitation in a petition, it's not supposed to be awarded, but you should be prepared to address it anyway, because most of the time the court is going to bring it up on their own. On the first appearance, if there's a problem with visitation such that the father has not seen the child for a while, then it's likely that the court is going to ask about some sort of temporary visitation order so that the father can start to or continue to see the children throughout the life of the case, because these cases can take quite a while. And so not only do they want the father to begin to have access to the children, but they also want to use that temporary visitation to see how it's going, because as problems crop up in temporary visitation, that gives the court an idea about what the family's problems are and what might need to be addressed. Visitation can sort of look as specific or as vague and general as the parties in the court want. So it can run the gamut from parents to agree on a reasonable visitation schedule and just leave it completely open-ended, which is really only appropriate for parties that can get along and that's been working for. And it can go all the way up to, scheduling the exact hour that he picks up the kids and the address that he picks them up from. He picks them up from the precinct at 5 p.m. and he has to return them the next day, Saturday at 8 a.m. at this other address. It can cover holidays, it can cover travel. In domestic violence situations or where the father is suspected to be dangerous to the children, then your client is going to want to ask for supervised visitation. Supervised visitation can either be supervised by an agency, and so in that case your client is bringing the kids to an office where there's a social worker and the dad comes to the office too, and the social worker observes and makes notes and provides a report to the court of how the visitation went. That type of supervised visitation is advantageous because you get a report. Can anyone imagine why that report might not be as useful as your client hopes? What's the father going to be doing when he knows the social worker's watching? Yeah, he's going to be on his best behavior, so he's going to look like he's a model dad most of the time. The other disadvantage of supervised visitation by an agency is that they're time limited, so they're expensive, your client can't afford them, and there's a long waiting list for the free services, and for the free services they're usually limited to, for example, 12, I think Safe Horizon is 12 visits, and that's it. That's not going to get you very far. So supervised visitation by an agency is not a long-term solution. It's not something that can happen after the case is over, really. It's going to be one of those temporary arrangements. The other way to have supervised visitation is to have it be supervised by a friend or family member. The downside of that is that, first of all, you and your client and the father have to find a family member that you're both comfortable with. So most of the time the client doesn't want his friends or family there because she doesn't trust them either, and he doesn't want her family there because he's going to think that's interfering with his relationship. The other problem is a lot of times the family members don't want to do it, because if that means they're on the hook every Saturday from 1 to 5 p.m. they've got to be at a certain place, and that's a hardship for them as well. So when your client says, I want supervised visitation, really talk to her about what's that going to look like in the long term and how are you going to make that happen, and really how is that going to address the problems that we have. It's very rare in New York for someone to get no visits. If the dad is asking for visits, it's almost impossible for her to have completely no visits whatsoever. It has to be the most egregious domestic violence, pattern of violation and just really terrible stuff. And that's going to be hard for your client to hear. But again, the courts consider that the advantage to the child of having some kind of relationship with the parent, even if he's a very problematic, violent person. They want to give him the benefit of the doubt that he can maybe change his ways, and they want to have the child have some relationship with that person. Of course, you want safety measures to be in place for the child and your client, but again, it's going to be difficult to get no visits whatsoever, so just set your client's expectation. Yes? Long-term incarceration, that's a good question. So most of the time we don't see visitation being ordered when the father is incarcerated. There was a case that just came out, was it last week or a couple weeks ago, where visitation was awarded to an incarcerated parent. I haven't read that case, so I don't know the specifics of it. I'm imagining that it would be because the father showed that he had some history of a relationship with the child before he went inside, and so there was some compelling reason that it was going to be better for the children to see their father in jail than to not see them. But, you know, especially if he's incarcerated upstate, it is really hard for your low-income clients to get there. It usually means getting up really early with the kids to take a long-term bus all the way up, you know, and then to have 10 minutes with the inmate. It's not great. It can be damaging to smaller children. So I guess the short answer is it really depends. It's always fact specific. But if he's not going to get custody when he's incarcerated. If he's asking for visitation, then you have to talk that over with your client and be prepared to address why that is or is not in the child's best interests. Any other questions on best interest or visitation? I want to run through a couple of example languages. So in this, I skipped ahead. There we go. In this sample here, this is a petition that a mother prepared by herself without an attorney, saying it would be in the best interest of the children to have custody awarded to petitioner for the following reasons. Petitioner states that she's the child's primary caretaker and she provides a safe and loving home environment for the child. So what do you guys think? Is this an adequate petition? Does this tell the whole story? Does this allege enough to survive a motion to dismiss? Let's start there. Any ideas? Think about the best interest factors that we talked about. What's one of the best interest factors that's present here in this sample? Yes? Primary caretaker, yep, good. That's about it, right? Do you think this is an unfitness case or a comparative fitness case, just based on what's written here? Comparative fitness, okay. So when your client comes to you and she's filed this, what do you think you want to do with her? What's your next step with her when you are assessing this petition? Yes? Find out the true story. So interview your client, see if you can get some more details, and then probably this is written vaguely enough that unless there was really nothing else there to say, I would suggest amending this petition to have a lot more detail and include a lot more of the story. The next example is a pro se petition by the father. It would be in the best interest of the children to have custody awarded to petitioner father for the following reasons. Her mother is unstable and claims she cannot afford to take care of her. I love my child. I have been there for her since birth. I can provide a stable home, private schooling, and give her attention. My job provides me the time to take care of her. What do you think of that petition? What do you think about the fact that he is relying heavily on his financial stability? Go ahead. That in itself is not adequate, and you want to ask, assuming your client is the mother, the respondent in this, you want to ask her about being unstable. Certainly being unstable, it's sort of a vague term in this petition, right? Does that mean mentally unstable? Does it mean that she has unstable housing? Does she live in a shelter that she might, is she about to be evicted? What does unstable mean in her situation? And is there anything that can be done to make her stable during the course of this proceeding so that the judge isn't afraid that if the judge awards custody to her that the kid's going to be out on the street in 6 months. So I did say that financial considerations should not weigh too heavily, but that being said, again, if your client is homeless and there's no home for the child to live in, then she's not going to, likely not going to be successful on custody. Okay, great job. So that brings us to our break.
Going over the nuts and bolts of a family court proceeding. So this applies to both order of protection and custody cases. So big question, what do I do when I get my case? So you're going to review the documentation. What you have in your file is what the client has given us when she talked to us by phone. So if we didn't have the documents, you'll have to get them from her. So see what documents are missing. Is there anything specific that you need? Do you have the actual petition that started the case? Do you have proof that the other party was served, and were they served correctly? You'll want to start spotting the issues on the case. I've already talked to some of you during the break, and you've already started spotting the issues. I anticipate that I should be filing for custody. I anticipate that he's going to want visitation every day. I anticipate that this case is going to not resolve so easily, or that it will resolve. There's room for that. So when you start meeting with your client, reviewing the documents, start thinking about what it is that you're going to do when you go to court. I mentioned this before, you're going to consider doing a court tour. You want to become familiar so that you're comfortable, get a sense of who the judge or the referee is, so that you're not so nervous. You'll be a little bit nervous, but you'll get a sense of the demeanor of the court. Family court is a little loose. It's not as formal as the cases that you're going to be seeing on your other during your summer. So you want to get a sense of who that judge is. What mood are they in? Generally speaking, they do treat associates, some are associates. They recognize that you're going there for the first time, and they'll give you some leeway, but not necessarily much. So you want to know the facts of your case. So one of the suggestions that I have is when you're going over your documents that you create a timeline and some biographic information so that when you're in front of the court, you're not like looking for, well, how old is this child? Something you should know. You're not looking all over the place for that information. And you'll probably be the one that has the most information. Oftentimes, if assigned counsel is on the case, they may not have had as much time, or I can guarantee you they haven't had as much time to meet with their client. If they're retained counsel, maybe they've had a little bit more time. But you want to make sure that if you have time to sit in the back of the courtroom, you'll ask the court officer if you can enter. You're going to be observing. And even on the day that you go in, maybe one or two of you, depending on the size of the courtroom, will want to go in and sit in the back until your case is called. It'll help get your case called a little faster, and it'll also give you a feel of what you can expect. I mentioned this before, visit the newyorkcourts.gov, and that's where you'll check the status of the case, and you'll be able to know what case is on. It could be that during the course of the case, during the time from which she filed to her next court date, something new has been filed. So if that's the case, you'll know it by looking at the court. If you don't see that docket number in your file, then you're going to have to go to the court record room and get that. As long as you have your notice of appearance, you can, or letter stating that you can go and review the file in advance. Review the sample documents in our material. We have pretty extensive manuals. You want to take a look at those. Review, we have a questionnaire in there. Go over the questionnaire with your client. Get as much information. Review the statutes that I mentioned before so that you're familiar with the case. Some practice tips. Again, review your manual. You're going to use it as a desk reference. We're here for mentoring and for answering questions, but I'm going to ask you, did you look it up in the manual first? Because I want to know that you've also, know the law, and I might be asking you questions about that. But certainly each case is different, and we're going to be strategizing individually about the facts of your case. So that's not going to be in the manual. You want to set up your initial meeting with the client. Let her know that she's going to be coming to the firm, that she shouldn't bring her children. Let her know who she's going to be meeting with. Find out if she needs an interpreter, and you'll arrange that with your firm. And make her feel comfortable. Just let, especially when she comes to the firm, it's a big, fancy firm, and, you're going to be sitting with her for a bit. If you sense that it's too much for her, then you can cut the meeting down. You don't necessarily need to get everything in your first meeting, but try and get as much as possible and help her feel comfortable for what you can expect when you go to court. And when we're doing the mentoring, we're going to talk to you about what you should expect when you go to court. We're going to ask you about the case history. What did you learn after your meeting with the client, and what her expectations are. You're going to engage your firm supervisor and keep them up to date. They may be sitting in on the meeting. They may give you leeway to draft petitions if necessary for your case, but they'll have to sign off on that. So keep your supervisor in the loop, particularly if you see trouble on the horizon. If something is not right, make sure that you speak to the mentors. Each of you assigned a mentor from Her Justice and a supervisor at the firm before that goes out of control. Hopefully it won't, but you want to make sure that you manage the client's expectations and that you're giving her proper advice. Always send us drafts. Some of you have to file petitions. I want to see that before it gets filed. We'll make some edits and changes and talk to you about whether you've met the standard. So make sure that you reach out to us for comments on the draft, and give us enough time, because there are about, 10 of us now that are reviewing cases, but we have 6 other trainings going on. And so we're reviewing, I think we placed about 100 cases this summer. So we're reviewing and working with associates on other cases. So 100, that's 200 people that we're receiving phone calls. So make sure that you give us enough leeway. Let us know what happened at the last court date. Send us an email, recap, think ahead about what the next steps, and make sure that you leave the courtroom knowing what you need to do. And knowing that if you got an order, that that order is the way it was stated on the record. Sometimes when you leave the courtroom, then you say, I don't know, what they want me to do. You want to make sure that before you leave, you make sure that you state on the record, Your Honor, as I understand it, this is what I need to do, or as I understand it, you're asking me to do X, Y, Z. So any questions on that? Okay. One of the helpful things is a timeline. I'll ask you for that when we're talking, so that I can get a sense of how much you know about the case. As I said, you're going to know probably more than anyone in that room about the specifics of your case. And you'll want to take those things into consideration when you're doing logistics. For example, you want to know where the person is working, what their schedule is, what the children's activities are. All of those things are important in doing settlement negotiation or even just an interim order. So next we're going to talk about gathering evidence on domestic violence. So we're going to look at some of these things that will come out of your question. There's a questionnaire in your material. Some of the things that will come out: date, time, location, duration. How long did an event happen? If you're going to be describing an altercation, where did it happen? Who was there? How long did it last? Those things are helpful. So a lot of the information that you're going to be getting is from your initial interview. Okay. Evidence. What is evidence? So there's basically 4 forms of evidence. We have demonstrative evidence, documentary evidence, real evidence, and testimonial evidence. So they're pretty self-explanatory. Demonstrative evidence would be what? You have a photograph, for instance, of where the incident took place. Documentary evidence might be what? Anyone? What kind of documentary evidence might you have in a family offense proceeding? Right, she says a medical record or a hospital record. You can have a police report as well. Real evidence in a family offense proceeding? What would be real evidence? Something physical, right? In the example that we spoke of, it would be a knife. Or maybe it was an object. He threw the remote control at someone. Not that you're necessarily going to bring that in, but think about what that evidence looks like. And then you have testimonial evidence, and that would be the prime witness would be your client, her testimony. And in family offense proceedings in particular, the cases are won on your client's direct testimony. How credible is she? How can she come across? Whether she's, emotional, that's fine too, or she can tell her story straight as though it, she's already distanced from it. But when you're gathering evidence on domestic violence, you want to know, what were the specific threats to harm? Was this a pattern? Did he say something the same all the time? Did he always threaten to harm you in a particular way? What was the medical treatment sought? And if so, can you get those records? So we talked about getting releases. If you anticipate that case is not going to settle, that it's going to go to trial, or even if not, just at the beginning of the case, you're going to be meeting with her. If she says, I went to the hospital, it's going to take some time to get records. You never know if the associates are going to need it at a later time on the case. So you might want to get those releases and get that information. And what were the types of injuries? Was it a bruise? Were there pictures taken? If she went to the precinct, maybe the police have a picture. Maybe she took a picture with her cell phone. If she did take a picture with your cell phone, what are you going to do? How are you going to preserve that?
Get a copy of it.
Someone says, have her send you a copy. Okay. So you guys work with IT people. So if you have to download something onto, a disk or a USB device, you want to preserve that. Okay. So I know that they have good IT people here. But each of your firm, that's the advantage. You have technology people. That's one way. Maybe she printed something off of Facebook. That might be helpful to you, and you want a copy of that. So you want to make sure that you try and preserve anything, especially if it's going to disappear. If there's a voicemail recording, you want to find a way to get that downloaded so that you can preserve it. Because if she loses her phone or something, then you don't have that as evidence. If there's any damaged property or weapons, you want to have her keep it safe, or if you need to hold on to it, make sure that you talk to your partner how you're going to preserve that evidence. So this isn't an evidence training, but we want to make sure that you flag these things so that there is a chain of custody on these cases, because in the future they'll want to know, well, where did this object end up and where was it throughout the whole time? Talk to her about whether children were present during the intake, and if so, what did they witness? Is that going to be useful in your custody case? Is it going to be useful in whether these parties can have a joint, custody arrangement? So think about that. Were there any witnesses to the injury or incident? If so, don't let her tell you, you need to use this person and she needs to come in and testify. You're going to make that call. You're going to assess whether that witness is a credible witness and an appropriate witness to bring in. Okay, and you also want to kind of be a little bit skeptical and say, is there some bias here? What is this person going to say? Is there any reason not to have this person, or is there a better person to bring in? Okay. You want to find out what the prior domestic violence history was, the orders of protection, violations. She may not necessarily have it. You may have to go back to court, and if there's a history, get the entire record from the court, and you can do that by going to the court record room. And then last is you want to start thinking about whether there's anything you need to subpoena. So if there was a 911 call, you want to subpoena that information early because it takes a while to get it. Okay. Any questions on the evidence? Okay. We're going to keep going on. Background material, that questionnaire, go through it. You might have to go through it again. Your client's story may change over time. Doesn't necessarily mean that she's lying. It may be that, it happened a long time ago. Maybe mean that she forgot something. Okay. It may mean that she transposed a date. She thought something happened on one date, but it happened on another date, and her petition locks her into a particular date. That's one where you might need to amend that petition. Get information on her primary caretaker history. Has she been the one to take the child to the doctor on a regular basis? How does she know who the teachers are? Does she go to parent-teacher conference? Oftentimes, when the parent is not the primary caretaker, they won't have that information. But it often boggles my mind that they don't have this information if they're free to get that information. They don't have to rely on your client to get that information. So it's something that you can use to say that the other side hasn't taken the steps necessary to know about their child. You want to know the school medical history. If there's a medical condition that's important to the visitation exchange and care of the child, you want to know that. If the child is asthmatic, does the other parent know to the extent? Do they know how to use a nebulizer? Do they know what medication to give the child and at what time? Are they participating in any particular therapies that the child is required to go to? Is the child getting a special attention at school so that, they need to be more focused on a Monday morning, and having a late Sunday drop-off is a problem. So there are a lot of dynamics going on, and you want to think, broadly about your case as to how it's going to impact the result that you want to get eventually. Again, if there are existing family court orders, you want to get them. If there are social workers, if your client is working with a social worker, keep in mind that there is a confidentiality. So you'll want to explain to your client that the privilege that she has with you is different from that which she has with a social worker. So if she happens to tell you, last night I was really upset and I spanked my child, that's one thing. But if she says it to a social worker, they're mandated reporters. So you want to let her know that if there's anything that's going on that's going to affect her custody, or the situation with the child, that she come and talk to you first. So one of the things is building a rapport with the client, confidence and trust, so that she can come and tell you these things, to make sure that there isn't inappropriate oversight on the case. So in that instance, if the child is spanked, it could be that an ACS investigation, Administration for Children's Services, is involved, and she's now open to more scrutiny. So make sure that you, if you're gathering that kind of information, if there is a social worker and that social worker needs to talk about the domestic violence, that you assess for yourself, like how much time has the client spent with the social worker, what kind of program it is, because they may be a witness. Some of the potential outcomes on the case is the following. Default, which means that only one party showed up. Hopefully it's your client. So in a family offense proceeding, if the other side doesn't show up, it's considered a default, and she can get an order of protection without the other side being there. The way she does that is by giving testimony. So if you have a case that's on for the first time for a family offense proceeding and the other side doesn't show up, they've been given notice to show up before and they just failed to do so, be prepared to question your client about the particulars in her family offense proceeding. And she will be giving testimony and you'll be guiding her on a direct as to that testimony. And the end of that could mean a final order of protection, which is much easier to do when she's not being cross-examined by his counsel. So if you have a default case, you want to go forward, you want to ask for the order of protection to be entered in favor of your client, and get through that questioning. It shouldn't be very, very long. Sometimes clients decide that they want to withdraw the case. This is totally within the client's right to do so. You may disagree with it. You may think that, you know what, she's going to end up coming back. Or you may think, you know what, if I were her, I wouldn't do that. But it's your client's decision. If there may be dynamics at play that she's not ready to tell you about, or that she's just knows the situation better than anyone. So if she knows it's better to withdraw and do and move forward, that's what she's going to do. A dismissal, if there isn't sufficient basis to have an order of protection continue, the case can be dismissed. The other side can ask for the case to be dismissed. Typically, though, they've passed through the first gate by letting the court, going to the clerk, and they've drafted the petition, and that usually passes muster, and cases less often get dismissed. On family offense cases and custody cases as well, but you'll have consent, and that's what Anna talked about. You want, the judges all want parties to get along. We know it's high conflict cases, but there is room to consent. So in a consent, particularly on a family offense proceeding, what that means is that there's not going to be a hearing. There's not going to be testimony taken. What it essentially means is that the other party says, I'm agreeing to have an order of protection. I don't want to go to a trial. I don't want all these facts laid out. For whatever reason, they choose to do that, and you can get an order of protection for up to 2 years. Anything beyond that would have to go to a hearing. What is, in practicality, what does the consent order mean? It means the same thing as if you went to trial. So if that person has the order of protection for a period of a year, and then they violate it anytime during that period of time, and she calls the police, that person, there's a mandatory arrest. If they violate it and she wants to come back to court, and then she can file a violation on that order. So oftentimes opposing counsel does not want their client to consent. They'll often say, well, she's going to call the police. She's just going to make stuff up and call the police. If there isn't a pattern of that, then that's not very likely to happen. But that's going to be some back and forth between you and opposing counsel if you want to consent and they don't. Settlement goes to the custody and working out resolutions to the case. And then finally, you have fact-finding and trial. Every time you're in front of the court, you're standing up, you're making a record. That's a bit of the fact-finding. It should be a little bit more formal in the family court, but it's not. So things will go on the record, and you're like, well, how did that get on the record? That shouldn't be there. It should be more formal. And then you have a trial. Okay. And then we're going to switch to adjournments. I don't like adjournments because family court is very, very slow. And so if you adjourn the case, let's say you're in court on June 15th, that case may not be heard again until after the judges come back from vacation, September. So by that time you won't be around. The other thing is you want some clarity for the client if there's going to be long gaps, and you want something solid in place. So look to see what she has now. In some instances, adjournments do help your client if she's not ready for trial and you need to prep her a little bit more. But generally speaking, there's something that can be accomplished at each court date. So you want to find out if there's a long adjournment, what's the potential impact that it's going to have on the client's case. You can do an adjournment on consent with notice to the other party, or you can make an oral application at your court date to say, we'd like an adjournment for, in 3 months. But you're at the mercy of the court's calendar and the other opposing counsel and everybody's schedule. So I'm not a big fan of adjournments. When you're in court, you want to request an extension of all the orders until the return date. So you don't want to walk out of the courtroom and forget that order of protection, that temporary order of protection, which extends to your next court date. You want to make sure that your client has that piece of paper in hand in the event, and we've had cases where they walk out of the courtroom and there's already a violation. You want to make sure that the client has that on hand if she has to call the police. Okay, so your first court appearance, everybody wants to know, what do we do? You want to check in with the part, request the translator if necessary, and have a conversation with the other side. So if the other side is represented, you're going to introduce yourself to the other side. You can find this information out on eCourts. If he has already been assigned an attorney, the name should be listed. Or it may be that very same day you approach the opposing party and you introduce yourself. I'm so-and-so's attorney. I'm representing her. Do you have counsel? And if they say yes, get their information. Are they going to be here today? And if they say no, you can speak to them. Okay, is this something that we can settle here? If you have a judge, though, I would suggest setting up a meeting with a court attorney if they're available to discuss, so that, because you're not representing the other side, they may ask you for legal advice and you can't do that. When you're in front of the court and you hear the word is issue joined, that means that the parties were properly served. Okay, so in that default case that I spoke about, he would have had to been served properly with the paperwork, either by the sheriff or the police department. Used to be police department, now the sheriff has been taking over. Or she might have said, no, I'll have someone serve him because I don't want a uniformed person serving him, because that'll be too disruptive. So you want to make sure that you take a look at that service. Most of your cases, if she's already appeared a few times, issue has already been joined, and there's no question of service. And on the record for representation, you're going to state your name. You're going to say that you're Summer Associates, that this is a pro bono case. You're going to indicate the name of your firm and hand up what's called a student practice order. And that should all be in your materials, because you'll be supervised by a partner or Summer Associate on the case, and you can only speak when that person is present. And we have these student practice orders so that you can speak on the record. If you get any pushback from any of the judges or referees on that, please let us know. Sorry. And on the table in the courthouse, you'll see a notice of appearance. You can do a formal one if you want to type it up in advance, but it's a very quick form that you can indicate who you're representing. You'll use the caption that's listed in your court papers. If they're cross petitions, and you can indicate that they're both petitioner and respondent in the caption. And you'll hand that up to the court. So on your first appearance, you're going to appear on the record. And what you want to do is state your client's position and respond to any allegations. To the extent that you can, if you can sort of set the tone and be the first one to speak. It's not necessarily a race, but you want to set the tone to what it is that your client wants. Some judges will say only allow the petitioner to state their case first. It's a few minutes. This is going to be very quick. Your court appearances, all of this anticipation, your meetings with the client, our hours. You're going to be standing in front of the judge or the referee for just maybe 15 minutes or so. It could even be faster than that. Especially if the court needs to adjourn, then it's going to be really fast. So what you want to do in that is explain your client's position. If something has happened in the interim, if she only has a refrain from order and you need to a stay away order because an incident has occurred, you want to be able to ask that. So it's good to have a checklist of the things that you want to say on the record, and hopefully you'll be able to get to all of them. And if there are accusations on the other side, if they're nasty allegations, you don't want to necessarily let those go by. You want to address, Your Honor, may I respond? My client was not at that location, or she was at the precinct, 10 minutes early. You want to respond to any allegations. If you need to amend the temporary orders in any way, make sure that you do it before you leave the courtroom. You might get shut down. The court may be a little bit impatient. They may not want to hear you on it, but keep in mind that every appearance you're making a record. So you're going to want to say, Your Honor, just for the record, I'd like to state, the following. Okay. If you need to amend any pleadings, for family offense cases, you can amend as of right 20 days after the service has been done. However, we've already gone, for most part, beyond the 20 days. So you will need to ask for leave of court to amend the pleadings. So usually you'll get it. Sometimes you'll get pushback, but you have a right to amend the pleadings. The court will set the adjourn date. Make sure that your client brings her calendar, that she knows appointments, because it's very difficult to reschedule. It's not difficult, but it's just a pain to reschedule any court dates because you have to now start chasing around all the people. And this might happen, it's out of your control. Something happened, the child is in the hospital, or there's an emergency that arises and you need to reschedule the next court date. So any questions on just that very broad procedure? When you talk to your mentors, we'll get into more detail. Any questions? Turn it to you.
Yep. Thank you. Okay. So I'm going to switch gears a little bit and talk a little bit just about sort of gathering evidence and some settlement, just to sort of let you know what our thinking is in terms of the amount of time we spend on the topics here. You guys are going to be at this case only in the summer, so that's why we spent a lot of time talking about preparing for the first appearance and your first appearance. That's likely going to be what you guys do. As Wendy mentioned already, this is not an evidence class. This is not a trial class. That's why you guys have these great mentors at the firms, so you can talk to your partner and senior associate about trial strategy. We're going to touch on that very briefly at the end, but we want you, from us, to hear just more about trial prep in terms of how it specifically relates to custody and orders of protection cases. So if you feel like we're rushing at the end through trial, I just want to let you know that is on purpose. That's why we do it that way, because you have these great resources at the firms. So that being said, specifically for custody and visitation cases, you're likely to have an attorney appointed for the child. Wendy has already touched on this topic, so this is going to be a separate attorney who represents the child's interests. Then when an attorney for the child is appointed, that child becomes a represented party, and that means that the rule against speaking directly to represented parties applies, which means you cannot speak to that child. The attorney for the child, the role in the court is actually to advocate for the wishes of the child. So although I said in my previous section about how the wishes of the child are not paramount, they are considered, and it's that attorney's job to express them no matter how immature or childish they are, as long as the child is verbal. If the child is not verbal, either because it's an infant or for any other reason, then the attorney for the child is going to be substituting their judgment on what they believe is best for the child. But other than that, their role is actually to advocate for their client's wishes, just like your role is to advocate for your client's wishes. They are going to interview the child, they might interview the parties, and they can also visit the home. The attorney for the child is not supposed to make recommendations to the court. That is not their role. However, The court does tend to take the attorney for the child's expressed views very, very heavily, and so it does behoove you to get on their good side as soon as possible. Certainly you want to be cooperative with them, and you want to ask your client to be cooperative with them. Another player that might get involved in a custody visitation case is ACS, Administration for Children's Services. Don't panic if you hear from your client that ACS has been investigating her. That might not mean that she's the subject of suspicion. It might just be that the court routinely ordered a court-ordered investigation, or COI. And that's basically a routine investigation, again, where ACS visits each party's home, takes a look around, and prepares a report about what each home looks like, whether it's safe and appropriate for children to live there. So you should review the COI to make sure that you know what's in there, and if there are things in there that are disadvantageous to your client, you can certainly object to them. But in general, hopefully this is a routine thing, and again, your client, just like with the attorney for the child, your client should be instructed to be pleasant and cooperative with ACS when they turn up at her home. This is also your opportunity. It might feel intrusive, but it's your opportunity to really get a sense of what his home looks like. And so if your client is saying that he lives in an unsuitable place, this is your chance to prove that, because ACS is actually going to go look at it. Aside from a COI and forensics, which I'm going to talk about, there's really no discovery in custody cases. It's seen as disruptive to the children and their relationship with the parents. And so a custody case is not going to be a place where you're going to be sending out subpoenas and doing depositions and interrogatories and things like that. You might be doing some of that in an order protection case. Wendy mentioned sending out subpoenas, for example, for phone records or police reports. In a custody case, that's really not considered appropriate. And so custody case is very much based on the testimony of the parties, any other witnesses that might have actual knowledge of what's going on in the family, the ACS court-ordered investigation, and potentially a forensic evaluator. A forensic evaluator is a mental health professional that is appointed by the court to do mental health evaluations, usually of the parties, sometimes also of the children. Judges give these considerable weight, and so you have to review them very carefully. First of all, you want to prepare your client for the interview with the forensic. Again, talk to her about being cooperative, being honest. Make sure that she's not coaching the children to say what she wants them to say, because that's going to be picked up immediately, and that really looks poorly on her. But then when you get the report back, it's going to be really important to look at the report and see how it reads for your client. And if it's problematic, you do have the right to attack it in court. A forensic evaluator is considered an expert witness, so you can cross-examine them. You can cross-examine them on their methodology used, or if they were relying on hearsay to make their recommendations and things like that. And again, I'm rushing through this because this is not an expert witness training either. There's a whole training that takes hours and hours that actually I think Wendy and I have both attended on, specifically on cross-examining forensics. If that becomes part of your case, talk to your mentor about it, and we can direct you to further resources. But aside from the forensic evaluator and potentially an ACS investigator, your main witnesses are going to be the parents of the child, or in an order protection case, the petitioner and the respondent. So every time you meet with your client, you're going to, in the back of your mind, be assessing her credibility as a witness, because there's only one trier of fact. It's the judge or referee, and depending on how she comes across in the fact-finding or trial can make or break your case. Can she survive a custody battle? Can she talk about really difficult domestic violence incidents while her abuser's sitting at the table staring at her? Does she tend to break down? Is her memory poor? I mean, there's many reasons why victims of domestic violence might present as bad witnesses. It doesn't mean they're lying, but there's study upon study about how domestic violence affects the memory of victims and survivors. You're going to be aware of that. The judge or referee might not be so cognizant of those things. And so you really have to be analyzing your client with a critical eye, because if she's not going to survive a trial, then settlement might be the best option for her, honestly. And so that's something that it's your job as her counselor and advise her to talk to her frankly about your assessment of her chances of being a good witness and at trial. Third-party witnesses, Wendy mentioned already, these are people that might have some knowledge either of the abuse in an order of protection case or just of the relationship between the parties in the family. If it's a custody case. So in a custody case in particular, you might want to be talking to teachers, daycare, childcare workers, pediatricians, those kinds of things. Be careful because you want to be mindful not to be bringing in hearsay. So if the only thing that a witness can contribute is, oh, my friend, your client told me that he hit her, that's hearsay, and that is not an appropriate thing to bring a witness in for. So witnesses are there to talk about what they saw with their own eyes, what they heard with their own ears. So again, teachers interact with the children directly, doctors interact with the children directly. Your client's friend who is her confidant and she told her everything about what's happened in the relationship might be a really good moral support, but she's not going to be a good witness. If you need to seek third-party witnesses, then the way to get them into court is to send a subpoena. For friendly witnesses, it's often a good practice to give them a call first and just give them a heads up. You know, it's a little bit aggressive for a kindergarten teacher to be served with a subpoena. That it is what has to happen to get her to show up at court, but at the same time, if your client has a good relationship with her, maybe she just gives her a heads up and says, hey, you know, this is embarrassing, but I'm in the middle of this custody case and the lawyer thinks that it would really be useful to hear from you. Do you mind talking to my lawyer on the phone? And if it makes sense for you to come to court, then you'll be getting an official looking subpoena in the mail and sort of have, lay the groundwork for that as well. We talked a lot about types of evidence already on Wendy's slide, so I only want to touch really on the things that are going to specifically relate to custody and visitation. So we already talked about school records, teachers. There might be hospital records if the child has special medical needs or if there was some injury to the child through the domestic violence. The court can order drug and alcohol tests if you're alleging that the father has a drug and alcohol problem. There can even be something in the visitation order that he has to pass a drug or alcohol test each time he comes for visitation, and if he fails the test that day, he's turned away from that visit if he's currently using. So those are things that you can discuss with your client to potentially put into the order. All right, so I wanted to skip through that and talk more deeply about settlement considerations because, as Wendy said, you can settle orders of protection on consent, but I think that more importantly to think about settlement is in the custody visitation context. I've sort of been alluding to or hinting at this in my previous presentation, but really custody trials are bad for everybody. They're bad for everybody. They're especially bad for the kids. They're stressful on your client, and it puts the parties in this terrible position where, you know, what is a trial? It's, you know, person A versus person B, and you fight, and then one of them wins and the other one loses, and it's this horrible way to set up a co-parenting arrangement. You don't want to have that be the basis for trying to go forward for the next 18 years, maybe, if it's a baby we're talking about. So again, there's exceptions, right? Domestic violence being a big exception, but I personally am a huge proponent of trying to encourage your client to think about whether her custody case can settle in a way that both parties are happy and reducing the conflict for the family so that everyone can kind of just move forward and get used to the new way. You know, when families break up, it's stressful. It sucks for the kids no matter what. They're just going to have to get used to things being different, but the sooner you can get past the conflict part and get to the rest of their lives, it's going to be better for everybody. Wendy talked a little bit about, again, settling orders of protection. What you want to think about for an order of protection case is if she's going to agree to something lesser than what she asked for, is she going to be adequately protected? And the other thing to consider is many times parties will have cross orders of protection or mutual orders of protection. And in a situation like that, it's very rare that both parties are equally aggressive to the other, right? There's normally a primary aggressor and maybe the other person was defending themselves and did something, and so now she has an order of protection against her too. Oftentimes the other attorney is going to want to come in and say, well, let's just agree to the mutual orders of protection, then we can all go home. I really strongly advise against that. The reason being that if your client has an order of protection against her and he's the primary aggressor, he's 100% going to use that order of protection against her in the future. He's going to be the one calling the police against her, making false reports, and she's going to have problems with the police going forward. This also might have some immigration consequences to her if she has, if she's undocumented, and you certainly don't want to be increasing police involvement in your client's life. So I would, unless there's a very compelling reason to do so, I would advise never settle to agree to an order of protection against your own client. Go to trial. You have nothing to lose to go to trial. For custody visitation stipulations in particular, you want to be as thorough and specific and comprehensive as possible. Your goal is that this family never has to darken the doors of family court again, right? So every potential future situation that could come up from age 0 to age 18 when the child ages out of this really ought to be considered. I mean, it's easier said than done, right? But do your best, okay? So when we're talking about parenting time schedules, we're talking about pick-up and drop-off times and locations. But then there's going to be exceptions to the regular schedule. So what happens if the father's weekend visit falls on Mother's Day, or what happens if it falls on Christmas, or what happens when the children are out of school and they want to go on a longer extended vacation. So you want to take into account special holidays. Holidays are often split, so depending on the religion of the parties involved. But if it's a Christian family, perhaps dad gets Thanksgiving and mom gets Christmas one year, and then it switches in the following year. Usually moms get Mother's Day and dads get Father's Day. Sometimes you share the child's birthday, sometimes you split it. But these are the things you want to talk through with your child. Think about everything if you can. If you're dealing with a situation where the baby is young, try to think about what happens when that baby gets older. Again, you don't want these parents to have to go back to court. So right now the baby's schedule is really erratic, and he's breastfeeding and he's sleeping in a crib and all this stuff, but eventually he's going to be 6 and he's going to go to school somewhere, and then eventually he's going to be 14 and he's going to want to be in a sports team and hang out with his friends on the weekends. You can't put everything into a stipulation, but try to think about these things. What happens when things have to be changed? What's going to be the procedure for the parents to talk about the child as he develops and gets older and has different needs? And then we talked a lot about decision making. And again, I want to stress that if you do agree to joint custody, which is fine with some exceptions, you still want to make sure that hopefully your client is the one having final decision making power. Sometimes what courts can do is craft settlements into what we call spheres of decision making. So let's say that dad is very religious and it's really important, he might be Orthodox Jewish, and it's really important for him that his children are raised in that faith. Your client doesn't mind as much, but it's really important to her that the children attend, a particular school or, whatever it is. And so you can actually split out the decision making so that dad gets final decision making on all issues of religion, whereas mom gets final decision making on all issues of education or medical, etc. So you can be creative and craft a stipulation as specific as you want. And of course, when you're drafting the stipulation, use the samples in your manual, but then please call your mentor and discuss it thoroughly, and please send your mentor the draft stipulation before you sign anything in court, because once the parties have agreed on something, as I mentioned at the beginning of this training, it is very, very hard to change a custody visitation order once it's done. Okay, so we are going to breeze through trial. Again, don't be alarmed, because this is going to be something that your partner supervisors can really help you more with, but we just want to sort of give you an overview, and I'm going to hand it to Wendy.
Thank you. So, boy, I need some water. Sorry. So even though the family court seems a little loose, there's still trial procedure and there's still rules to follow. Oftentimes we don't think that the court is following it until you go on appeal. But what you want to do is make sure that you follow the rules of evidence. So first and foremost, the judge wants to see that your evidence is relevant. So what does that mean? It means that it has some reasonable tendency to help prove or disprove a particular fact. It doesn't have to make that fact 100% certain, but it increases the likelihood that that fact is going to be true. So once that is admitted by the judge as relevant evidence, they say, okay, that's relevant evidence, thank you. The court will look to see, is that evidence competent? Does that evidence follow the traditional notions of reliability? So think of a situation where something happened in the middle of winter. You can look at the weather report to see, was it snowing on that day when he pushed her down across an icy road?
The CLE code is LS5 4ZP. LS5 4ZP. LS5 4ZP.
And then the court will also want to see if it's material. Does that piece of evidence is it considered material if it's offered to prove a fact that's in dispute? So if the fact that's in dispute is that, she called 911, it's material to bring that piece of evidence, which would be the 911 record or 911 dispatch call into the case. Okay. So those are the pieces of evidence that you want to bring in. And the trial chronology is basically, you'll make an opening statement. And this happens, it could happen in different ways. This is not necessarily set in stone. But generally, the idea is that this will come across. You'll make an opening statement. What is the theory of your case? What is it that you're going to try and prove? If your client is the one who's the petitioner, then you'll do the direct examination of your petitioner. That's the easy part because you've already spoken to your client. You haven't given her the answers, but you've talk to her about what the questions are, and in general, this is what I'm going to be asking. I'm going to ask you to describe what happened on these particular dates. Hopefully she will remember the dates and be able to say what happened. You're not going to you're not going to lead her. Well, isn't it true that he hit you with his right fist? No. Describe what it is that happened. Okay, so that's your petitioner's direct. Then there will be an opportunity to cross-examine. So it's very important to help prepare your client for that cross-examination, because if think about it, if there's a pro se adversary on the other side, then you're going to have the abuser, cross-examine your client, and I've seen that happen. It's not fun to have an abuser who knows their client better than anyone, and can push those buttons to cross-examine your client. But generally speaking, hopefully the court will have assigned counsel, or there'll be retained counsel who will cross-examine, and that isn't always easy for your client, so you want to make sure that you prepare her for that cross-examination. After that happens, that is your case in chief, then you would rest on your case. And you can bring witnesses, those witnesses that Anna spoke about, you can bring them into your case. At the end of your case, the other side can say, well, or if they're the petitioner, you can ask for the case to be dismissed if they have not made out a case. Most times the court will let the case go forward. And then the opposite happens, the respondent will bring his case, and he'll be on direct, and then you'll have an opportunity to cross-examine the respondent. You're probably not going to get, and it'll be frustrating, you're probably not going to get the person to admit that they did those things, and that's okay. The idea is to poke holes and look to the credibility. And in family offense cases, your client's testimony is really what's going to drive the case. Okay, so if you don't get that gotcha moment, that's okay on cross-examination. And then each side will make their closing statements. Okay, so in family offense cases, you have 2 phases You'll have the fact-finding phase. It's all under the umbrella of a trial, and the dispositional stage. So the dispositional stage is basically where the court decides, what am I going to do here? Am I going to give a 5-year order of protection, 6-month order of protection? What am I going to do? And for that, the evidence that you bring in is going to be competent and material. So if there have been violations in the past, you want to bring that in as evidence that maybe there should be a longer a term on the order of protection. In some instances, after your case is decided, or before the judge makes a determination, if it's a really complicated case, you can ask to do a post-trial memo. If there are, interesting issues of fact, the gentleman earlier said that he was talking about an incarceration case. That might be a good case to do a post-trial memo. Is there some case law here where you can point to direct the judge's attention as to why it's not appropriate? Hopefully that would have been done in your case, but maybe there's some case law that would warrant a post-trial memo. And then finally, you'll get a court decision. Most judges will either issue a bench decision, or if they're more thoughtful, will write out a decision, particularly in a custody case, if there's a custody dispute, and then you'll wait for that order. Also, the judge can ask throughout the case their own questions. So if they interrupt you, that's fine. And because it's your trial, you want to make sure that you preserve your objections for the record. And again, you're going to be working with the partners if this comes up to make sure that you preserve your objections for the record, because some of these cases do go on appeal. So again, for strategies for direct examination, as I mentioned before, avoid leading questions. You're going to use open-ended questions. You want the client to tell her story. So what happened next? It's not your show. You don't have to, prepare a lot and just like focus on your questions. You want to guide her gently and have her tell her story. That will lead to what's most credible. Because if you're feeding her the answers, they're going to think that she's not believable. There are some prompts that you might have to give a client because her memory is not quite there, but that's why you want to take the time to make sure that she's ready and able to withstand the trial and she's able to articulate her story. You want to avoid compound questions. You don't want to bombard her with 2 or 3 questions on direct. So what happened when on this date, and then tell me what happened next. You want to make sure your questions are simple, and you want to listen to her answers, because you might have prepared her in one way, and then she'll just throw you with some other thing that, oh man, I forgot to say it, but she thinks it's appropriate to say it now, which is fine. You want to be guided and listen to her, and that might take you in another direction. You want to. That doesn't speak to being organized and logical, which is what you want. But if she goes off course, that's fine, because she's telling her story. On your case, you want to volunteer weaknesses. So if she happened to scratch him during the course of an altercation, you may want to volunteer that, because you want to make sure that the other side doesn't cross-examine him on that, or cross-examine her on that. And you want to anticipate objections throughout the case. What is the other side going to say? What are they going to bring forward? And again, you want to prepare her for cross-examination. On your cross-examination of the respondent or whatever witness that the other side may have, you do want to ask leading questions. Isn't it true that you have not attended one parent-teacher conference in the last year? Yet they want to have legal decision-making about school. Okay, so you want to this is your opportunity to tell the side of the story. You want to keep it short and simple. You don't want to give the person wiggle room to be able to say, well, I didn't attend parent-teacher because she never told me when it was. She changed the schools. There goes your theory of why he wasn't able to go to the parent-teacher conference. You want to limit it to the subjects that were raised on direct. So he would have been directed by his counsel, and you're limited to your cross-examination on the questions that they were asked. You don't want to ask why. Why do I say don't ask why? I'm asking you, why don't I say why? Why?
Because you don't know what the response will be.
You don't know what the response will be, of course. If you don't know what the response is going to be, you don't want to ask that question. It'll open up a can of worms. On the other hand, you do want your client to get in as much information as possible when she's being cross-examined. Yes, you want to know from your client what is the witness, whoever that may be, is going to say about her on the stand. It's not technically a stand. It could be just like a little room. Some of the rooms are very tiny, so it could be that the person's just kind of right next to you or on the other table. So it isn't, don't expect it to be a big formal room depending on which courthouse you're in. But so you want to know what is the witness going to say about your client so that you can prepare and, again, anticipate and correct anything that might make her look bad. It could be that she was in a rehab program, and they'll say, well, she was in a rehab program. And, you know, the response might be, yes, but I went to treatment, and I have certifications that I've been sober, and I'm doing all the things that I need to do to care for my child. For a cross-examination, you want to focus on attacking, so to speak, the credibility and the perception or recollection of the individual. If there's a criminal conviction passed and it's relevant, you want to bring it up. If it's not relevant, you're going to get objections to it. If it's something that happened a really long time ago, if I were opposing counsel, I wouldn't want to let that in. If there's a witness who's a particular biased witness, you want to make sure that you cross-examine them as to their bias. If they're hostile, you don't want to engage with them in that sense, but you want to, that will come across to the court. If they've committed prior bad acts, if there have been violations of orders of protection, again, you want to bring that forward as best you can. Reputation for truth, prior inconsistent statements, these are all, things that you might want to bring if there's, you're questioning someone. We don't do depositions, but if they said something, on direct and then they say something on cross differently, that might come in as a prior inconsistent statement. Or if they said something on a police report and then they say something different, that would come in as a prior inconsistent statement. Okay, so any questions on trial or any questions about evidence? Yes?
Would you want to show the client the court beforehand or before she has to appear there?
She probably already went to court, so, but if she's nervous or if there's, you might want to go with her. But you might just want to explain the layout to her, so that's why it's good for you to go. As I mentioned, if she's going to testify, it might be comforting to her that it's a small room and she's going to be able to maintain contact with you. Or that, we've even had some instances on the front end of a case where the client is getting is doing a video conference. It's not usual to ask for it at this stage, but it is something that the courts have taken into consideration when there's a safety issue, and they have been doing video conferencing on the initial the time when the client files the family fence proceeding, and if for some reason she doesn't want to go to court or can't make it to court, they can do a video conferencing. So that's something that the court has become more progressive about lately. And then finally, your next steps. Again, everyone's going to do this. I'm not telling you to read it back to back or to just memorize it cover to cover, but just, go over the statutes, go over the manual, go over your cases, set up your meeting. If you have any problems reaching your client, please do let us know. You should be able to have you should have an email address and a phone, hopefully a backup number or a work number or something to reach the client. If you cannot reach her, please let us know, and then set up a call with us after you've met with her. Okay, so that is it. We're going to open it up for any questions. I know that some of you do have your cases already, so I'd kind of like to hear what your thoughts are on the cases and what you think you might run into. Now I'm going to pick on the folks in the back because we've already talked a bit.
Overtime, too.
We're meeting with the client on Monday. We're going to get more information from her. There was an incident in which her husband was arrested, coercing her, and so we want to learn a little bit more about that. It would be very relevant to his claim for visitation.
Right. Right. So hopefully they'll have a good meeting, and then from that they'll think about next steps. Do they have to file a petition? Okay. So we are out of time, but if anyone wants to come to us and ask any particular questions about your case, please do so.
And thank you for taking on a case this summer. Hope it's really rewarding.
Thank you.
All right. Thank you.
I don't